Okay, we now have a quorum and we'll begin the closing the Justice Gap Scope Subcommittee meeting. This meeting is being recorded, and with the permission of the co-chairs, I will start with roll call.
Great, please do.
Okay, Thomas Green.
Yes, here.
Rebecca Sandifer.
Here.
Marta Alkenbrock.
Here.
David Engstrom.
Here.
Micah Star Liberty.
Here.
Kevin Moore.
Here.
Toby Rothschild.
Here.
Patricia Scutiero.
Here.
Thank you.
Okay.
So Mimi, I presume we have a quorum?
Yes, we do. And if there's any members of the public who would like to give public comment, please use the raise hand function to indicate that you'd like to do so. You'll be given 2 minutes. It doesn't look like anyone is indicating that they'd like to give public comment.
Okay, great. And do we have public members on? Just off.
Yes, we do.
How many?
Oh,
roughly?
actually, we do have one. Well, hold on. Mir Tariq, would you like to give public comment? His hand was up for a second and okay. We do have one, so I'll let him begin. Hold on. Mir, are you there?
Hi, can you hear me? I've been just entered into the meeting. My quick question is
loud and clear. Go ahead.
So we will hear some content and then give some comment, or this is the right time to give comment?
This is the right time to give comment. Please do.
Okay, I don't have any comment right now. I'm sorry. I just wanted to clarify the rules. Thank you.
Oh, okay. No worries.
Yeah.
So Mimi, back to Becky and myself.
Yes.
Okay. So thank you very much. We're looking forward to a good working meeting. I owe thanks all around the table. Firstly, for everybody willing to give us an extra hour, that is very much appreciated. We're hopeful that we'll actually make a fair amount of progress today. I also wanted to do special thanks to Kevin, Marta, Micah, and David for their very thoughtful input, just terrific stuff. And then I just want to talk about sort of at least Becky and my sort of vision of today and the focus. So the mission here is to try and arc towards at least a rough draft of what an application might look like. I don't think this is going to be, we're not going to preclude anything today. We're not going to exclude anybody today. What is the real mission here is what information do we think we need for this process to go forward? Now, some of that information may, in another meeting, result in somebody, the trap door opening underneath them and they'll be whisked away in some chutes or ladders kind of way. But today it's just what is the information that we want to get from potential applicants for the sandbox. So in our preliminary sense of this at the highest possible level is that thanks in particular to Marta and Kevin, when you actually look at that side by side, or at least as we looked at it, our perception was there was good stuff on both sides of that in both columns. And so what we thought we'd try and do is structure the conversation in a way so that we could start with what seems like the logical place to start for an application and then work our way through the big issues. And
okay, Tom, before you continue, we still need to address some housekeeping stuff like staff report and the approval of the action.
Oh, I'm so sorry. Yeah, please go ahead.
Okay, is there a staff report, Randy or Andrew?
Just one reminder, there was a doodle poll that was sent regarding the meeting dates for 2022. Yes, it's almost time to start filling your calendar for 2022 and ask that you please respond when you can to the doodle poll.
Actually, Randy, that poll was only sent to leadership initially. We haven't sent it to the entire working group yet.
Well, then my comments are directed at the leadership team, and please look forward, everybody, to the dates for next year. It's coming soon. Thank you.
Okay, great. And Mimi, anything else we need to cover?
Approval of the June 4th open session action summary. If I could get a motion.
So moved.
Second,
Do we have a second? Oh, Tom, you're seconding? Got it. Okay.
Yeah.
I'll take a roll call vote. Tom Green,
yes, aye.
Becky Sandifer,
Yes.
Martha Alkenbrock,
Yes.
David Engstrom,
Yes.
Micah Star Liberty,
Yes.
Kevin Moore,
Yes.
Toby Rothschild,
Yes.
Patricia Gutierrez.
Yes.
Thank you. Now we can go ahead with the rest of the agenda.
Great, thank you very much, Mimi. So what we want to do is to essentially weave our way back and forth between the Arizona application and the Utah application. The idea being that we're going to try and pick up the best of each application. There are some issues that are just going to hang out there because Arizona in particular maps to a particular regulatory structure, which is referenced in their application form. So we're going to leave some of that stuff by the side of the road, at least for the moment. So why don't we go ahead and get started? And so the first thing, hopefully the first useful thing, if I can ask Mimi to turn to page 9 with the combined draft from Kevin and Marta. So there's just briefly while she's bringing it up, this seems like the obvious place to start. So it says applicant entity, please describe the applicant entity. So keep going. I think
So, Mimi, could you increase the size of that
Yes.
a little bit? Please?
Page 9 of their document, or you're talking about page 9 of, oh, sorry. Okay.
yeah,
Okay,
this
there was
one.
a cover sheet. Got it. Okay.
So this struck us as sort of the place to begin. I mean, this should be all pretty plain vanilla, but these are the bits of information. And then you can go to the next page too, Mimi, because we think we want to go. So take a look at this. And again, this is page 9, page 10 of the combo that we got from Kevin and Marta. The only wiggle here, there's some reference to Arizona, which Becky and I can clean up. The other, go down to the very bottom, if you would, Mimi. There is what is in fact a term of art, principal, designated principal. In the Arizona system, there are two significant personages in their regulatory scheme. The designated principal is the person who is obligated to communicate directly and pretty much at any moment with the Arizona bar staff. So that's a role inside of a Sandbox participant. The other aspect of this, which is not referenced here, but just be aware of it, is there is something called the compliance attorney. So this is analogous to what we've seen in the United Kingdom. A compliance attorney is the attorney that's obligated, and this is in the ABS context, if it's an ABS entity, that that person is responsible for making sure that the attorneys inside the ABS follow all of the bar rules. So those are the two concepts. But I think otherwise, and I'd love to get take a look at this, but basically this is all the basics of the firm or the corporation that is applying. So I'm assuming, and I'm hoping you will agree, that this is something we can all agree probably makes sense for the application form. So thoughts on this, on these 2 pages? And while you're thinking, at least in terms of what Becky and I would like to do, is assuming, for example, you say yes to this pretty much plain vanilla thing, we'll include that in a draft new form, clean out the Arizona references, and then come back to you with a new document, which hopefully will include much more than this, but at least will be a starter document for us to work off of. So why don't I go to you, Kevin, since this was one of the things I think you guys kind of liked, but.
When you say you're going to come back with a new document, I assume that it's just going to be a straight out application form.
Yeah.
No comparison, everything will just be folded in together. If we're leaning in that direction. Yeah.
And then further to that process, I want to underscore it, that it would be a draft. I mean, this is, if you say yes and we decide later this doesn't make sense, but I think we're at a sufficiently inchoate stage of the process where a draft would probably make sense. That's the method and the madness, but go ahead.
No, that's fine. That's pretty much what Marta and I contemplated. This was just to give folks an idea of what's in both applications. And then we could discuss whether, what we could pick and choose from each application that would be appropriate for the California application. So do you want to, my only question is, in the cover memo, we submitted, or I guess it was an email that was transposed into a cover memo. We also suggested a reorganization of the application. Do you want to put that off until later, or do you want to?
Yeah, let's put that off till later, because I think we have a kind of a threading that kind of makes sense to us, but you guys can certainly push back as we go along. But let's try this first.
Okay, so we're in part 4, which is really trying to get at specific information, background information about the people who are going to be involved in the Sandbox entity. And we wanted to expand the questions, the amount of background information beyond what appears to have been asked by Utah, perhaps more along the lines of what Micah suggested in her memo.
Mm-hmm. Yeah.
So, yeah, I'm okay with your suggestion of including this information. And as you mentioned, there are terms of art here that we would have to define at some point, I think, either in the application or separately by perhaps a California rule of court that might be the authorization for enabling these Sandbox entities. So, yeah, I have no qualms with what you have suggested, Tom.
Okay, great.
Or as part of an overall statutory scheme that would have to go through the legislature that would authorize the Sandbox, as opposed to just a rule of court that Kevin mentioned.
Right, that's true. We have a different set of a different constellation of sources of rules and regulations than Arizona did. But yeah, for sure. Okay, so is there any objection to this being at least part of the application form?
I have no objection, obviously, but along those lines, and I know like Kevin and I communicated with Rebecca and you, Tom, about as we were drafting this and as Kevin and I were talking about this, we had mentioned even for our last meeting when we were working together is to have somebody from Arizona come and speak to our group. And Rebecca mentioned that was something that was handled by the state bar and they were going to try to, and I think they were involved in getting somebody from Arizona to come and speak to us. Is that in the works?
I'm not sure. Is that Randy? Is that something you can speak to?
Yes, John London and I have exchanged emails about the planning for a speaker from Arizona, and there are some folks that have been identified. We know we have an upcoming meeting in August of the entire working group.
Right.
I think leadership is still trying to consider whether at that meeting, when we have a lot of work we want to accomplish, whether the bandwidth can accommodate the usual 2 presentation chunks that we've had previously, or maybe this would be a 1 presentation meeting. If so, Tom and I have also been talking about the technology speaker, which the leadership team also asked us to explore. And so we probably have a technology speaker that's ready to go if that is the call. But it is in the works. And if it's not at the next meeting, it'd likely be at the following meeting. And John Lund is sort of taking the lead on the Arizona speaker.
That'd be great. And at least from my perspective, let me just do a little lobbying here. The Arizona Supreme Court order, I mean, it's really a gorgeous piece of work, frankly, but it's the 7-209G, cap G, like in Gobbler or something. That's the provision that has the principal definition and then the compliance attorney definition and the responsibilities, which I'd love to have somebody explain that to us in some detail, but just one guy's view. Okay, is there any?
I'm sorry to interrupt, but Randy, what's the technology speaker that will be coming? What is that on?
And so part of the expectation is that some of the innovative applicants will have delivery systems that are technology driven. That was a large part of the ADLS study and report. And what was also identified by ADLS was the special concerns that are raised by such delivery systems, technology driven delivery systems. It's been referred to as quote unquote dark patterns. And so that is everything from the technical compliance with industry and federal law regulations concerning privacy of information submitted through technology, as well as the aspects of online delivery and marketing of services that have proven to be perhaps challenging to regulate from a consumer or client protection standpoint. And so these so-called dark patterns, such as mandatory arbitration when you use an online service, that sort of a thing, would be addressed by the technology speaker, as well as demystifying some of the basic aspects of, can technology really engage in the delivery of a legal service? Can artificial intelligence give legal advice? That was also something that was presented to ADLS, and I think this group will benefit from hearing about that in connection with the focus on regulating to avoid the dark patterns.
Is that sufficiently responsive, Mark?
Yeah, thanks. I was just curious as to what that is. Thank you.
Cool. Okay. So any objection to us? We're going to be a little bit soft in terms of this, but I would like to get a sense that this is okay. I think I've got that. Does anybody object to using this language? Okay, hearing none. Let me turn to the next piece, which is on page 10, Mimi. It's down at the bottom. Also on the Arizona side. Page 10 of, yeah, keep going. No, you got to go down. Down one more. Keep going. So we're looking for 4.1. Okay, stop there. 4.1. So this is, again, is sort of general information. And it's what we propose, or what I'd love to get you to assent to, is a combination of the two. List all persons and entities who wholly or partially direct the management or policies of your proposed entity, et cetera. that at a high level and then add the specifics that you see in two little I's, which is on the Arizona side of the page. Does that, any objections? Going
My
down?
only comment, I would note, I noticed, Tom, that that list, as well as the one we were just talking about, includes social security number, and I would want to be really cautious to only capture that information if it's absolutely necessary. I'd
Why don't
rather not have information in my records that I don't need.
Yeah, I mean, that's the personally identifiable information, the PII question. We, at least in my world, we protect that. Why don't we just put a footnote next to that, and we'll make that a subject to additional discussion. But that aside, is that, and actually the email address may be an issue as well. But setting those two aside, does this make sense to folks? Going once.
Tom, can I just ask, are you talking about all of the information, all of the several pages of questions that are under the Arizona application on 4.1?
We're going to do that as a separate bit, Justice Tucker. It's just the basic contact information that I'm mentioning right now.
Got it. Thank you.
Yeah. And keep me honest, Micah hopefully will be particularly alert to this, that if we don't capture it, the next page or so is very detailed stuff, and we do want to capture that. But I think it flows better in another spot. So any objection? Going once, going twice. Okay, let's assume that works. And then, Mimi, if you could turn to, it's 4.2, which on mine is the bottom of page 12. So what we would propose to you is that we would take from the Utah application 4.2, which is this point, list all persons and entities who will wholly or partially greater than 10% finance the entity. So that should get, I mean, the broad sweep of this is to capture all of the key management players, all of the key ownership players. And I think that's the sort of the broad brush of who are the key people within the entity that we want to know about. Any objection to adding that to our potential draft? All right, I'm hearing no objection. Okay.
Okay, no objection, but just to clarify, that's somewhat duplicative of the other questions. So this would be maybe the lead question, and then sub questions before would be included below.
That's a great editorial point. I think that's absolutely correct.
Okay, all right. Just wanted to
And then-
clarify. Thank you.
Yeah, no worries. And let me turn this over to Becky. So the broad brush of this is that we liked some of the broad requirements for descriptions of what are they going to do and how are they going to do it. And Becky, you're on.
Great. So we've already made enormous progress. We've asked who is doing this, right? So what is the corporate entity that will do this, and who are the specific people involved? And so then the next set of questions we like to turn to is, what do we want to know about what they're actually doing? So could we turn to just the first page of what Kevin and Marta put together? So what do people think about first asking, just describe what it is that you will provide from the perspective of a consumer, which is what the Utah question does on the left. Who provides the service? How do consumers find it? And what will it do for your customers? This would certainly not be everything we would ask, but it would be like an opening query. What do you think you're doing?
I don't have any objections to 1.1 from Utah, with the caveat that, you know, at the Arizona that could then follow.
Yeah, exactly.
Right.
Yeah, and the other thing, when you say opening query, that would be the opening query as to the proposed services, not necessarily the opening query of the application.
Absolutely. Absolutely.
Right.
Okay, so we're okay with that. Hearing no dissent. Then could we turn to page 3 of what Marta and Kevin put together? So first we ask, what are you going to do? And then 1.4, who are you going to do it for?
Well, the 1.4, on the Arizona application, I think that, pardon me, on the first page again, it kind of goes up to business objectives, which may be a same or similar type of questions.
So one thing to do would be take Arizona's approach, which kind of puts together the regulatory objectives and the business objectives. Another thing to do would be to split them apart. So what do you want to do? Who do you want to do it for? And then later you would ask, okay, how does what you describe yourself doing relate to these goals?
Yeah. So our thought was it seems cleaner to separate those two ideas, but certainly open to discussion.
Okay, I see what you guys are, I'm understanding your thought process is how you're kind of organizing this. I don't necessarily have any problem with that. So what you're talking about is then from a 1.1 go to 1.4. Is that the logical flow that you're moving through?
Yeah, that's
Okay.
what we were thinking.
Okay.
Yeah, to recap, your first, what are you going to do? Second, who are you going to do it for?
Yeah.
And then you'll finally get around, explain how this is going to accomplish the goals that we have identified for our sandbox.
Got it.
Yeah, exactly right. Yeah.
Do we at any point want to ask in this questionnaire how much they're charging?
That's an excellent point.
If so, maybe this is the spot where you do that.
Becky, to you, do you want to include that?
I mean, I think,
Or an estimate, you know.
as a general rule, what I would ask is, what regulatory objective is that related to? And how would knowing how much they charge answer the question about that objective? Like, so is the information useful to the regulator?
Let's just make a note. If you go back to 1.1 and right-hand column, second bullet point, promoting access to legal
Good
services.
point.
You know, the
Yeah.
cost is going to be a factor there. So I think that could be a sub-question under that second bullet point.
Well, and then how do we deal with, I mean, one of the concerns that I've heard vocalized is whether something starts one way and then there's the intention that it's scale. So how do we capture, if we do, or if we can, whether or not there are plans, like if they think it's a scalable model and what that looks like and what the cost differential will be from the beginning when it's smaller to, you know, global, for example.
Yeah,
I think that's a great issue to raise. I think one thing to think about is whether that is some part of how the entity thinks it's responding to the objectives. And so maybe when we talk about, we're going to talk about the specific section in just a minute. Maybe when we talk about that, we can think about what we might want to know about cost and what we might want to know about plans for scaling or assessment of scaling or something like that.
Yeah, there are, one of the reasons we have this speaker coming to talk about dark patterns, and he's going to also talk about scale. I think it's a set of very important issues for a technology-based offering. And I think we may still need to do some work for the tech people, frankly. But I think Becky's point's well taken in terms of cost and that sort of business. It certainly bears on important issues. But I think the next conversation is going to be about that, or at least relate to it more closely. So, Becky, back to you.
So if you'll let me get through one more boring question, then we can get to this really interesting set of issues that people have raised. So we have, what are you going to do? Who are you going to do it for? And then can we go to page 4 to Utah 1.6, which is essentially what substantive kinds of problems do you propose to assist with? And the list the list is to be determined, right? That's going to reflect what's eligible activity in the box, but that's the idea. What are you going to do? Who are you going to do it for? And in what areas of problems, life, law, however you want to think about it.
Going once, going twice. Michael, go.
What's the question? Is this inclusive enough, or?
Yeah. Is this language good to go in terms of a next draft? Is fundamentally the real question. So.
I would add workers' compensation.
Oh, that's a great point. Cool. Okay.
But I guess it's TBD with respect to some of to the categories. Well, because I think some.
Mm-hmm.
Well, yeah. I mean, my assumption is I hear what you're saying. We have to allow them to develop something in these areas. I just wanted to clarify that employment would not include workers' comp, just in case there was some confusion. But yeah, I mean, certainly not, from my perspective, a thumbs up on all of these categories.
Okay, to use Tom's language, going once, going twice with the categories TBD.
Okay.
All right. So then that takes us to the interesting one. So you've said what you're going to do, who you're going to do it for, and in what kinds of problems. Can we go to page 2 to Arizona 5 and Utah 1.2? So this is the how is what you're doing going to oversee service provision so that you achieve these goals. So I think one of the questions that it would be really helpful for this group to think about, Arizona has 5 bullet points. Are those the right bullet points?
Can I ask a question about Arizona 5? Like, why is that framed in terms of lawyers, given that these innovations are often going to involve non-lawyers? Am I missing something in that?
That is an excellent point, David.
If
Yeah,
I could try to respond. The
Well,
Arizona.
one
is
just
there-
editorial comment. I'm so sorry. The Arizona app says one or more, so you may not. But anyway, go ahead, Kevin. Go.
Yeah, the reason why it's focusing on lawyers, the concept in Arizona is they have alternative business structures, perhaps multidisciplinary practices where you have a number of different professionals providing different services. But the lawyers would provide the legal services, the accountants would provide accounting services, economists would give the economics advice or whatever, and so forth. That's the concept is there. That's why I think you see the specific reference to lawyers. And the other concern that they might have is that you're not going to interfere with the lawyer's independent professional judgment. That the management isn't going to do that, that it's still going to be the client is whom you're serving, regardless of whether you're in a business entity type situation. That's why those questions are being asked and why we may want to modify them somewhat.
Yeah, I mean, the closest analogy in California, I mean, it's an imperfect analogy. There's a thing called corporate practice of medicine. So if you buy a practice, if a hospital buys a practice group, the hospital can't run it. There has to be a medical director that guarantees that the doctors are doing the doctor stuff and the profit motive isn't overwhelming, the medical judgment of the physicians who are in the group. So that's the structure that Arizona has for these ABSs. If we go in the ABS direction, that's why this kind of makes sense. But it's key to this, what we might want to do with ABSs.
I had a question. I'm not sure what they mean by the ABS maintains proper standards of work. Not clear to me what that means.
Not clear to me either, I must say. But
yeah, the way I interpret it, whether it's correct or not, but the Arizona people can tell us, are they competent? Are they maintaining the standards of competence and so forth in the delivery of legal services? Competence, loyalty, confidentiality, and the like.
So I'm not a lawyer. Therefore, I might say, how will this management structure ensure that the entity provides competent legal services, period?
Or just quality of service?
I don't know that quality of service is going to capture Kevin's concerns. I mean, I think what he's saying is broader. He's bringing in our ethical obligations, candor, confidentiality, all of those things. I think, I don't want to misspeak, Kevin, let me know if I'm wrong, but competence to me is, did you fall below the standard of care? So this is broader.
What, Kevin, did you want to respond?
That's, Micah got it, what I was trying to get at, that it was broader than just competence. I started with competence, but then I realized if you're just going to refer to standards in the plural, then we should probably consider the other lawyer duties toward clients.
Yeah, but Kevin, to you, I mean, that's in the context of if they do an ABS thing, right? And you've got you're protecting the lawyers in the new box, correct?
Yeah, it's lawyers. I think that it might go even beyond that in an ABS, because if the concept there is a one-stop shopping, so you would also want to maybe make sure that the accountants are maintaining their standards and any other professional who is providing services to the clients who are going to this entity for multi-professional services, that they are being satisfied in every respect, every type of relationship they have with the entity.
So I'm hearing then 3 at least substantive things that this group is talking about as objectives. So one is the provision of competent services. And Kevin's raising the question of whether the sandbox would regulate only the legal services or the entity's entire portfolio of services. I would encourage us to bracket that for a minute and just get agreement on competence as an objective. So I heard competence. I heard that the provider, whoever or whatever it is, makes decisions in the best interests of clients. And I heard that some standard of confidentiality, which, going to David and Kevin's really excellent memo, is a complicated question that maybe we also want to bracket for this moment, but the confidentiality and privacy are protected by this entity. So we have competence, best interest of clients, and confidentiality. There's also this idea of independent judgment.
Correct.
Is that something that this group thinks applies? Well, who does this group think that applies to?
It's going to apply to lawyers who are working within such an entity, unless a decision is made by the regulators to suspend that requirement for a particular sandbox. We might want to make a note right now is to inquire of our Utah folks, how they're dealing with the Pearson Butler situation, which actually is an ABS. It's a multidisciplinary practice. And they specifically, because of the complexity of their organization, they got a little bit of a pass originally as to the conflicts rules. But then there was a supplemental memo, and I forget when that came out. That may have come out as one of the, I think it was Angela might have sent it out to us before all the materials were available for this meeting. I can't remember exactly, but there was a supplemental thing on the Pearson Butler Sandbox participant.
Yeah, is this the amended order? I think this is the one she
It
sent
might
out.
be the amended order as to what they're going to do with conflicts.
Yeah, it's dated March 22nd, 2021.
That's correct.
Okay. I think everybody should have that.
That's what I'm thinking of.
Yeah.
So I suppose there are any number of things that we might want to consider, but it can be a really complicated issue. And I'm not sure whether we should get bogged down in it or whether we just should try and go through and try and address some of the others. I mean, other than that, we really need some assurances that certain standards of the legal profession are being satisfied, or perhaps they are going to request that we suspend certain standards. I hope not, but an applicant might do that. I think if an applicant comes in, I think from the applications I've reviewed in Utah, they typically have asked for a suspension of the fee sharing prohibitions that still exist in Utah's Rule 5.4 to a certain extent. And they also say, except to the extent that the person is complying with the Supreme Court order governing the sandbox in Utah.
Okay. So Becky, what do you think? Should we try and, is there more we can extract here? Or do you want to roll this over and kind of leave all these notes in place and we can try and push something back to the group as a whole?
Yeah, I think these are all great considerations about how to achieve some set of goals. Are we content for now that the goals in this section that we want them to explain that they are achieving are independence, competence, confidentiality to be defined later, and making decisions in the best interest of clients.
Yeah, I'm not sure I would describe these as goals of the entity.
There are goals for the entity.
Yeah. Or their requirements, their basic requirements for membership in the Sandbox. We may want to address that. But again, I think that this is going to be a bigger discussion that we may need to have as to what rules should we even consider might be relaxed, or do we need to require that there be the confidentiality, the loyalty, the competence. We got off a bit several meetings ago when we were talking about what was the minimal competence that was required. Some people took the position that it had to be at least of the same standard that lawyers would have, and others said that it might be a lesser standard. So I'm not sure that we can have a fruitful discussion on that right now. If we could maybe go through and see what other suggestions you have for the application, and then when we get back the written form, we can take a look at it and you can flag those issues for us again.
Yeah, why don't we do that? I mean, because the goal here really is, to capture on paper, who, what, where, when, how, those kinds of basic issues, tell us what you want to do, etc. So this may be sending us down a road that may be too challenging for, and certainly not one we've sort of set up for today. So Becky, to you, thoughts?
I think that's absolutely right. I think we have something to work with for that now. So I'm going to take us to page 1, Arizona 4. So these are the regulatory objectives. So describe how whatever it is you're doing will advance one or more of the following regulatory objectives. And I think this is something of a substantive conversation about what should be on this list. And I think this may be an instance where, because Arizona was thinking about ABSs as parallels to law firms, the way they structured their objectives reflect that. And that may be appropriate to what we're doing, and we may need to modify it somewhat.
Well,
let's see if we can get some agreement on keeping some of them in.
Is
everyone okay with protecting the public interest?
I hope so.
Okay. How about providing, let's see here. Advancing the administration of justice and the rule of law.
With all due respect, that's kind of a word salad. I don't know what that means. That's fine, but I do think these bullet points are operating at very different levels of abstraction. Some are right in the heartland of what the whole purpose of the sandbox is, promoting access to legal services. And others seem to go up to a much higher level of abstraction and start to move outward from what I would think of as the heartland of the purpose of the sandbox. So promoting the public interest, I mean, that's another bullet point that strikes me as less tractable, because of course that's what anyone thinks they're doing that wants to come. That's what everyone thinks they're doing all the time. And so yeah, I guess I wonder about some of those. And maybe this goes to to a broader point, which is that I sometimes think there's virtue and open-endedness in these things. I think I said that in a prior meeting. And so I guess I would encourage us at key turns like this one to think about something that feels a little bit more open-ended rather than priming the response with a lot of options.
And in that regard, David, which of these meet your sort of open-endedness criteria, if any?
I guess what I mean by open-endedness would be supplying fewer bullet points.
Okay.
Now, you know, now that I think about it, like having a very capacious bullet point, such as advancing the administration of justice and rule of laws, is an open-ended invitation to like talk about what you think you're doing. So maybe that's entirely consistent. I mean, maybe. I mean, I'd be interested to hear what others think about that. But I guess I do think that there is that virtue and open-endedness, and I think it's sometimes easy to overthink these sort of things and to get into the frame of mind where we think this is going to be a one-off up or down application process. It's not. It's going to be an iterative process, and so what we want to do is to create an application that can help spotlight potential problems that can serve that iterative process.
Mm-hmm. For me, I think that the fourth bullet is probably inappropriate. I don't know that it's one of the objectives of our work to, to encourage a strong, independent, diverse legal profession. I'm not sure that's what this is all about. It might be a good thing, but I'm not sure what that's what the Sandbox is about.
Yeah. Of course, that's one footnote. Of course, that's in the Arizona context, and that's the ABS with the compliance partner and all that stuff. So, yeah.
Tom?
Ma'am.
So one of the things that I was wondering as I was looking at this is I know that this group was going to go back to the scope statement or the mission statement at a subsequent meeting, and it seems to me that maybe once that is completely finalized, that will drive this filling in filling in the bullets here. And that might really set that up, because even, as I'm looking at this, following along with what David said, protecting and promoting the public interest. We know our goal is to protect the public. Is what they're going to do, promoting the public interest? It's promoting the interest potentially of people who are using it. But is it the public interest generally? I don't know. But maybe our mission statement will help us frame this.
So Donna, I think that's a great point. And maybe what we could get agreement on now is we're going to ask any applicant to describe how its business will advance whatever the regulatory objectives are determined to be.
Perfect.
Much more succinct way of saying what I was trying to get at. Rebecca, thank you.
Well, you said it first and you did all the work for me.
Okay, cool.
All right, so now I'm going to bounce it to Tom to talk about consumer data.
Okay, so thanks again to Kevin and David for their just very thoughtful work in terms of confidentiality, et cetera. Again, recall that what we're looking for here is just kind of the basics of what a form might look like. So there are bits and pieces in both models which are interesting. Mimi, if you'd go to page 16 and bring me up the Utah side of this.
Can you give me a number, like 4 point something?
Yeah, well, it isn't a number, but it's under the heading selling of consumer data disclosure.
Got it.
Okay, so this, This struck me as being really not even close to enough, but it's a useful thing. Are you going to sell people's information? I think that's a useful question. So I think I would add that. I would also, and then again to you, Mimi, page 6.
One second.
So we were hopscotching all over the place.
Yeah,
So
I'm just updating my notes. 1 second. Okay, page 6.
Yeah, no worries.
Oh,
What
I
number?
have I have a quick question about the selling of the data, because is there going to be an option for people to opt out of selling from the data?
Well, I think that's a great question, Patricia. That's going to be, one of the, what do we want to do with this information once we have it? So I think that's a question down the road, actually. But I think collectively we want to get at least that information. And then, Mimi, are you at page 6?
What are we looking for? What number?
I am looking for 12 and 14.
12 and 14.
Page 6.
On the Utah side?
No, on the Arizona side. Okay, stop there. Okay, so when we looked at this again, I thought, at least at a high level, this seemed to capture the kind of thing we were concerned about. So 12 says, describe your policies and procedures for protecting client information. And then 14 is explain procedures developed to ensure confidentiality of client records. I mean, we could get more detailed than this, but I think 12 and 14 from the Arizona app, I think would surface crucial issues, but I would certainly defer to Kevin and David as to whether you think this kind of gets us at least in the ballpark of where we need to be. So there would be 3 things here: sell, no sell. 12 is describe your policy and procedures for protecting, and how are you specifically going to ensure protection of confidentiality. So Kevin, you want to give that a shot, and then I'll switch to David.
The only concern that I might have, I'll just address the sale of confidential information. I think we have to ask them how they're going to protect the confidentiality of client information, records, and so forth.
Mm-hmm.
But as far as sale of confidential information, first have to ask the question, will these entities have an attorney-client privilege? And as David's and my memo points out, that provides, the attorney-client privilege provides an important incentive for client candor that enables a lawyer to obtain the necessary information to provide effective and competent representation. If California has taken the position that in nearly every instance where it's been addressed, and the federal courts have done the same for the federal attorney-client privilege, that there's no such thing as a selective waiver, that you can't just selectively waive it as to one party. Yeah. Generally, once it's waived as to the world. So the question we always have to ask, and I think we need to make a note, if there's going to be sale of confidential information, particularly if information, you might say just factual, but if it is information that you've only acquired through a client communication, and I don't have an example right now as to what that might be. Under those circumstances, it could end up being a waiver of the attorney-client privilege as well. So I'm kind of against it. I would like to hear a little bit more from England, our friend in England, as to how this is handled in England. Are any of the people who are providing these legal services, non-lawyers or whatever, do they actually engage in the sale of client information, customer information, or is that something that's prohibited there?
Yeah, I don't know.
It also seems to me we have
David?
to take into account the California privacy laws that are much more extensive than Utah or Arizona as to whether it's even allowed to sell the data, particularly without consent.
Yeah, although I think, I mean, David can speak to this because the California Consumer Privacy Act has some requirements that actually turn out to make this not as universal as I thought. But David, do you want to just briefly touch base on that?
You know, one thing you could do is you could put the onus on the applicant to say and ask the applicant, how do you plan on complying with California privacy laws vis-a-vis customer data and info?
Mm-hmm.
Yeah, the wrinkle, I think that's a great suggestion, Neil, but the wrinkle is that you have to be a certain minimum size before the CCPI applies to you. So small entities would be out, you know, that.
Well, that's
they wouldn't have an obligation.
then at which point we can try to determine whether we want to impose any other additional privacy
Yeah,
rules.
true. Yeah, absolutely. But David, I cut you off. Go ahead.
Sure. So a few thoughts in no particular order. I'm fine with 12 and 14 as a way to elicit some information about what kinds of structures and procedures and, you know, managerial approaches might be used to ensure confidentiality. I guess, you know, if we're really just focused in on those framings, I don't necessarily see what additional work 14 does over 12. They seem pretty similar to me. I don't understand how a complete answer to 12 doesn't then just generate a C12 under 14.
They use the
So
word procedures in both. Yeah, that's a good
you know,
point.
if we want to streamline things and not overwhelm applicants and not create potentially distracting and counterproductive, you know, conflicted answers as between two questions, then it may make sense to try to streamline. So I guess I would say, you know, 12 says both policies and procedures, and that seems to get the job done from my perspective.
If I could jump in, the only thing I thought there might be a difference, and we might want to clarify it ourselves in the questions. One might deal with communications. How do you protect client communications? And also an emphasis on protecting the client records. So it could be 12, but then provide maybe parenthetically records, communications, and so forth with clients.
Great.
Does that work for you, David?
Yeah, that's absolutely fine.
Yeah, that works for me.
You know, beyond that, and I think Kevin started to go down this road, there are lots of substantive questions here. So, and I'm happy to defer those if what we're really trying to figure out is a nice, clean way to get some sense of policies and procedures here.
I think the mission for today is that latter.
Okay.
Yeah, I mean, that's
great. Well, I can leave that aside. You know, at some point we really will have to decide the substance of the memo that Kevin and I wrote, where we decide what are the confidentiality rules going to be. Are we going to level up and require that non-lawyers honor all the confidentiality rules that the lawyers operating within a sandbox or lawyers operating outside the sandbox in California would have to comply with? And you know, I have lots of thoughts there, but it sounds like you just want to leave that aside in the interest of moving forward and really getting this application buttoned down.
Yeah, I mean, this is the easy part of the task, it seems to me. So let's get this done. But yeah, thank you. And I'm actually looking forward to that conversation because you two just identified just a host of fascinating issues. But okay. So I think
Randy has his hand up.
Oh, Randy, go. Yeah, I actually can't see
Thanks.
the participants here.
Appreciate it. Thanks, Micah. Thanks, Tom. So just one quick interjection with regard to protection of quote unquote confidentiality. There is this concept, at least as to attorney professional responsibility, that protection of the confidence of the client isn't necessarily revealing secret information. In fact, it was codified into the rules, comprehensive rule revisions that became operative in 2018. And that's the concept of use of clients' information. Now, the rule is maybe a little bit more narrow than It might otherwise have been, but it's use of information to the quote unquote disadvantage of the client. And when you're thinking about technology-driven delivery systems, where you might be using, again, artificial intelligence, and we'll get this when we get a text speaker, but that depends on big data and the use of the information. If you're going to be doing the type of legal services where you're representing a lot of people on very discrete issues, and you're going to aggregate that data and use it to feed your artificially intelligent system to be able to have a better chat bot, or better give a better advice bot, then at least as a matter of transparency, I think protection of the client information would include not just saying, well, we're not selling it, but also being candid that, you know, you might have a very confidential mediation where everything is super secret under California law, but we're going to actually use that information to feed our AI. And I think somehow that ought to be built in so that particularly the tech applicants know that that will be something going forward that they would have to address.
So back to you, Randy. It strikes me that policies, procedures for protecting may not be enough. So use is maybe a word that should be included.
I think that would signal for them what we're getting at.
Okay, and because again, this is for the application, not for, you know, any prohibitions, but use here. David, Kevin, that's okay, right?
Sure.
Okay. Okay. That seems like a good amendment. I think that's it for, at least for the moment, for me, for consumer stuff. Let's turn to, there is a Utah question, which actually appears at page 2. It's 1.3, Mimi.
Just before we move on to that, can I suggest that edit that Mimi just made, that we actually have use be a separate bullet point? Because by putting it in this way, it sounds like use is to be avoided.
Yeah, actually, this is one version, and then I have my notes version. I just put in a separate sentence. This includes the use of client information.
My point is just leave 12 alone. No, leave 12 alone. Have another one that addresses use, because it's not protecting against use. To describe whether and how you intend to use client information for anything other than the service of the client or whatever.
I think that, Randy, that I think captures your thought, right?
Absolutely, because I think some tech providers, at least what we learned from some of the ADL's presentations, if the information we're using to sort of feed the brain of our tech-driven delivery system, if we can't do it, then we're dead in the water. We have to be able to do that. That's part and parcel of how we're going to scale up this activity.
Yeah, okay, I think.
Okay, I put that in my notes as a separate bullet point.
Okay, and then to the broader group, I'm losing discipline here. So with these changes, this approach to getting information about consumer data and how private information is going to be handled, that's good to go. Any objections? Going once, going twice.
I mean, I think the framing of the language we just put in may depend on what we decide substantively. We may decide that there's there's no voluntary, i.e. commercial disclosure of information within the sandbox. That could be a substantive conclusion that we arrive at, in which case the information we just added would read a little strange. It would seem to suggest that you can use it. You can voluntarily disclose it for commercial purposes, or to create a revenue flow that you can use to subsidize the provision of the services that you're providing. You know, so I guess I'm fine with that language, but I think as with some other points in our conversation today, we're likely to circle back once we nail down some of the substantive provisions.
Yeah, that's a point well taken. I mean, if it looks like the state bar is endorsing selling of people's private information, that's obviously a lightning rod. But let's leave it the way we've described it, and then we'll
yeah, it could actually be a trick question in the application. If you describe policies for use, you automatically get denied. So.
Well, if I could just jump in, and not to
Andrew,
prolong the conversation, but to David's point, where we'll have this conversation later, in particular with respect to use. I think if there are caveats with respect to using it to the quote unquote disadvantage to the client, there's protection there, or the ability to anonymize the information. If there's a way that an applicant could prove or show that the information is actually going to be used to enhance and improve services to other folks, just speaking for myself, there might be a way to quote unquote use that information. And that might be an interesting conversation for the group, you know, when we get to that point about fleshing this out and putting details on it.
Down the road, for sure. Great point, though. Okay, let's turn to, this is a general question in the Utah app, and it appears, Mimi, at page 2, it's 1.3. This is just a, yeah. So, and then can you go down just a little bit to show the text underneath it? Yeah. So this may be more important, this highlighted text, which is to the effect that explain to us why you need to be in this sandbox and in some fashion protected from having certain things applying to your activity. So that, you know, that surfaces, I need a change in the fee shifting and fee sharing, or I need something associated with whatever. So this is just I think a pretty easy question with very important answers for us, frankly. So that's the idea. So I thought that was a pretty nice lift from Utah. Toby, go.
Yeah, I like the alternative language that's proposed on the form. It's under the Arizona. It's also in Kevin's, or the
I like that too.
Footnote.
Yeah,
it makes it clear that it's not just, you know, it's more specific as to what it is that exactly that they are.
Yeah, I could certainly accept that.
Can't do.
So
whichever one of these we go with, whether it's 1.3 or the possible additional language, I would recommend against using the word traditional to describe rules governing the practice of law. I don't know what that means.
I agree. I think that's well said. The current rules are the only rules that matter. But you could just take out the word traditional and have the rest. On the possible additional language, I think we might want to add the word waivable. Be specific as to which waivable statute or rule of professional conduct currently prohibits, blah, blah, blah. Because I think we're going to have to get permission from the legislature to waive specific statutes. And so I think that word will focus people on the fact you can't just ask the Sandbox entity to waive statutes. They have to be statutes that the legislature has a priori said that the Sandbox entity has the right to waive these for appropriate applicants.
Yeah, that sounds, I mean, that just in terms of being appropriately deferential to the legislature and its powers, that makes completely good sense to me. Okay, so that's the question on tell us why you need to be in a sandbox. With these changes, any opposition? Does this work for you guys for the next draft of the form? Any objections? Okay, then I'm going to send it back to Becky on risk assessment, et cetera.
Great, thank you, Tom.
Yeah.
So Mimi, could we go to page 8, to Utah 2.1, I think it is. So when we were looking at what everyone put together, so what we're going to talk, you can imagine two kinds of risks. There are the risks to the consumer from the business model itself. And then there are risks that might come from the people who are staffing it. So we're going to separate those questions for now. So this is the assessment. This is what do we want to know about the risks of the stuff the organization proposes to do. So Utah says, can you fully and candidly discuss the risks your customers might face if they use your model, including, and then what would be included is to be decided. So the SAGE group is working on what are the risks that the risk-based framework would monitor, and then the whole group will have a conversation about what those are. But the question at this point is, is this a useful way of asking applicants to tell us what risks they see?
Well, while everybody's thinking,
Could
let me
I
just,
add
oh,
something
go ahead, Kevin.
that got dropped in the transformation of the table into a PDF, because there's or it just wasn't included in the original, for which we apologize. The Utah application actually identifies certain things. That's what it's referring to, risks described above. And they ask the Innovation Office must assess whether new legal service models cause consumers to get inappropriate or otherwise flawed legal results, fail to exercise legal rights through ignorance or bad advice, or purchase an unnecessary or inappropriate legal service.
I don't see that
It's-
even in their application. This is really
It's-
weird. Like,
It's actually there. It's in our PDF, Kevin. It's there. It's under 2. It's just above 2.
oh, which is above.
Yeah.
Ah, it's really, really long. Okay, so it's in the row above, Kevin.
Yeah.
Okay.
There it is. Keep going.
Okay.
And I think definitely that would be part of those, whatever those risks end up being would be referenced in that question. But the way this large committee has divided its work is the other subcommittee is taking the lead on identifying what those substantive risks are. And then the whole group, of course, will have a conversation about it and make a recommendation, but that's TBD at this point, what the risks to be managed are.
Becky, you led off by saying that there are risks that derive from the business model, and then there are risks that result from, I don't know, the providers. Is there a second set of questions that we're about to move to that would capture the other half of that?
Yes, yes. This is just, what do we want to ask about how what you propose to do is risky?
I'm imagining myself being the lawyer to the Sandbox entrant, and I want the answer to be, there are no risks, at least none that aren't fully and adequately addressed in 2.2, which may be an argument for merging the two questions. It may also be an argument for just viewing with a grain of salt whatever answers we're going to get here. I'm not sure. But
I was thinking the same thing.
So one thing that could be made explicit in 2.1 is that if the applicant is actually requesting the complete suspension or modification of an existing requirement, either rule of professional conduct or waivable or modifiable statutory duty, then I think calling those out as being a risk, if you will, is something that's objective and reviewable. And so it would lead to, under 2.2, the applicant being able to explain that if we are asking to completely abrogate the prohibition on fee sharing in order to address the harms that that rule is intended to prohibit, this is the mitigation that we're going to do. Here's how we're going to approach it. But I think the foundation for that is laid if under 2.1, you actually list the provisions that you're looking to change in order to have your innovative delivery system go forward.
Mm-hmm. So
So are
back
we-
to Becky, or yeah, go
Are
ahead.
we comfortable with this pairing of 1 and 2? What are the risks and how will you manage them?
Mm-hmm.
Okay, So then that takes us to 2.3, which is, please describe your consumer complaint process. Do we want this? Do we want to modify it?
Where are we? I'm sorry, I'm adding to my notes. So I'm trying to.
Yeah, we're at 2.3. We can see,
Okay.
we can see 2.3.
Okay.
Yeah.
Oh, that's definitely needed.
So I think whenever you ask about the consumer complaint process, you also need to ask how they will ensure that users will be aware of the consumer complaint process.
Yeah, this is one guy's views, not the co-chair, but this would be a good spot for disclosures about whether mandatory arbitration is part of the deal too. But.
Absolutely.
Yes.
So how is a consumer complaint process different from a way that one might identify and track risks? Seems like a subset. Maybe it's an important subset and we want a specific discrete question about it. I could imagine a refashion 2.2 and 2.3 where for 2.2 we focus on identification and tracking. That would include maybe specifically, describe your consumer complaint process. That would be a 2.2, and then a 2.3 would be about mitigation of the risks.
I think that's nicely clean in an analytic way. What do folks think about David's proposal?
But a consumer may just not like the outcome of the service. It's not a risk. There's not a problem with the model that was proposed, but the consumer doesn't like the outcome. They don't like the way they were treated. They think that that one of the individuals didn't follow the confidentiality rules, and they need to have a place to complain.
Right. I totally agree.
I mean, I would say that those are risks of a particular business model. If you have a highly leveraged system with a lawyer at the top and a bunch of non-lawyer providers below, and your managerial control over those folks is not great, then that creates the risk that people won't like the treatment that they get, or that they'll have concerns about whether their confidences were being kept. And so, I don't know. I guess I like the analytic separation of the two. The sequence or the series of identify, track, and mitigate. Those are such different things that putting them into a single question risks that an applicant will focus a bunch on the first two and not the third. We won't get much mitigation. We'll get a lot on identifying and tracking. Or alternatively, they'll seize on the mitigate. They'll talk a bunch about mitigate, but not give us a whole lot of detail on how they're going to identify and track. So I think analytic separation might still make sense.
And in the question about track, we could specify that we want to know about the complaint process there, including information about your complaint process.
Yeah, or you could just break 2.2 into two parts, and then 2.3 would become 2.4. But conceptually, I like David's approach. And you did as well, right, Becky?
Yeah. So if we went with that, we'd have 2.1. Tell us the risks. We'd have 2.2. Tell us how you're going to identify and track them, including your complaint process. We'd have 2.3. Tell us how you're going to mitigate them.
Oh.
Except it seems to me that a complaint process is about identifying, tracking, and mitigating specific instances of risk, whereas we really want them to identify, track, and mitigate risk whether or not it leads to complaint. Right. So while I agree with David analytically that a complaint process is part of what the answer in 2.2 would be, I would like to think that the answer will be much richer and more multidimensional. And I would be inclined, as a result of thinking of it that way, to put 2.1 and 2.2 as they previously existed into a single umbrella question. And then because it's a particularly important thing that everybody needs to address, please describe your consumer complaint process.
So we would have then, under this proposal, describe the risks, describe how you will identify the risks, how you will track the risks. We can pull them out as bullet points and say you have to answer to each one of these, and how you will mitigate the risks. And then there'll be another question, hey, tell us about your complaint process.
Yeah.
Yeah, if you did it as sub-bullets, I think that would work.
Yeah, that's great. That also addresses Donna's point, I think, doesn't it? Yeah.
Okay.
All right. So is
Sounds like a winner.
everybody okay with that?
Yep.
Awesome. All right, I'm going to bounce it back to Tom.
Okay, so this goes to eligibility, and I think this is kind of one of the core elements of what I understood to be the very thoughtful critique from Micah, Kevin, and Marta, that there was a need for more specificity and detail. So there at page 8, there should be a Utah 3.2.
3.2? Okay.
Yeah, 3.2.
Okay, got it.
So this is sort of general. I'm not precisely sure what this is actually intended to do, but I think I would just put a version of this as a placeholder, and then just hold on to it there. And then so hold that thought. And then I really like Arizona's far more lengthy. Tell us about you and your potential record of misfeasance or malfeasance, and maybe that flops over to 12 as well. But I think we should try and incorporate all of that, and to Micah in particular, if we've not caught something important, you might want to suggest some amendments or just get back to us if there's something. I think this is quite complete, but I know Micah was thinking about this much more seriously than we were, I think. But this seems to be quite a good list.
Where are we in the Arizona application that you're referring to?
You're right there.
Oh, so section 7. Okay, you said 12, and so I got confused.
Yeah.
Right. Okay.
No worries.
Arizona.
Yeah.
I think the wrong bit is, do any of the questions in the Arizona form that we're looking at now ask about outstanding debts or bankruptcies?
Yeah, good question. I'm not sure.
Civil judgments, outstanding civil judgments.
Those are great questions. It looks like right there, bankruptcy. Mimi, do we have copies of this? It's hard for me to read when someone else is scrolling.
Yeah, sorry.
Yeah.
Yes, they
You do
were
have
provided as a link. If you go to the first page of Kevin's document, there's a little memo there, and there's a link you can click on to open it. Now, this is a combined one that I created for presentation purposes, but what they're referring to is the Arizona ABS application, and we're on page 6 of that.
And in terms of the side-by-side, Micah, if you can bring that up, it starts at page 11 on the right side. And if it would be, I mean, it's a lot of text. I can certainly try and rip through this if you want to read it. And then just for to have a complete thought on the table, There, on page 12, there's, if somebody checks yes for a criminal matter, there's a specific additional set of pieces of information you've got to provide.
I think there's here under 15, been a party to or claimed an interest in a civil proceeding, including but not limited to bankruptcy too.
Oh yeah, bankruptcy lawsuits, yeah.
That might address the comment that was it Neil had.
Yeah, good catch, Mimi. I think that's correct.
Has somebody looked at the requirements of AB, whatever it was, the ban the box legislation that passed a couple of years ago? And if so, is this consistent with it? Or would we be asking to be exempted from it for the sandbox?
What is, I'm so sorry, what is the ban the box legislation? But what?
Something Bridget referred to during one of our meetings. And I don't remember the number of the legislation, but I know our state legislature a couple of years ago or so passed, my recollection is that they passed a statute in an interest to make it possible for people who had felony records to get reemployed. They passed some limitations on what employers could ask about criminal history, I believe.
AB 1008.
1008?
Okay. Why don't we?
I don't know that that would apply here because it's not an employer, employee, or 1099 and, you know, contract or situation.
It may not. That may be exactly the answer. I just wondered whether somebody had looked at it.
Yeah, that's too important not to, what, this to the staff. Maybe you guys could take a look at this. I don't want our application to be violating any state laws. So
I'm reading it right now. It says, just in brief, it says existing law prohibits an employer, whether a public agency or private individual or corporation, from asking an applicant for employment to disclose or from utilizing as a factor in determining any condition of employment information concerning an arrest, detention, blah, blah, blah.
so it is
blah.
employment, at least that. Yeah. Okay. Cool.
I think as part of moral character, attorney applicants might still be asked about their criminal history. I can double check that.
Okay.
Okay.
I think that's right.
So in terms of certification, I think it's I don't know for sure, but we'll take a closer look at it.
Yeah, take a look. I don't want us to get into trouble here or us lead people into darkness or something, but yeah. Thank you.
We can compare it against the moral character application, though, as you indicated. Micah may have that sort of more off the top of her head than anyone else at the moment. But one of the things that I think, and it's sort of interesting in this terms of this context, but one of the things that I know we look at in moral character that I'm not sure is here is whether somebody committed an act constituting the unauthorized practice of law, which, as I said, is sort of interesting in this context to be asking that question. But to the extent that they didn't have the authority to do it previously, that might be something that we would want to know.
I think that's a great question.
I know moral character folks definitely look at that saying,
yes,
you know, if you are already doing it and you shouldn't be, how can we trust you not to do things you shouldn't do?
I'm looking at the moral character application right now, and question 41 states, have you ever been convicted of the violation of a misdemeanor or felony?
Oh,
check yes
yeah.
or no.
Okay. All right. With the suggestion that,
But we'll still take a look at how that legislation might apply to
but to folks more broadly, Donna's thought about, you know, whether you were practicing unlawfully sometime in the past, is that makes sense to me. But thoughts, objections, going once?
No, I think that's a great idea.
Okay.
I think it's worth asking the question. I don't think it's disqualifying, but I think it's worth raising as part of an overall look at character and fitness.
What's the question again? So I could just make a note.
Add a question on any instances in which they were practicing law unlawfully. I'm sure there's some better way to put it.
You can just
Unlawfully and got caught, or just unlawfully? Like, are you going to admit to us that you did it?
For your notes, just say engaging in UPL, and we can flesh out the precise language.
All better. Okay,
So, well, sorry, while we're on this topic of the kind of moral character of the applicants, do we have questions related to the entity itself? I mean, some of them will be brand new corporations, I imagine, or maybe not even completely formed yet. I don't think we have any requirements with respect to that, but if it is a corporation and does have a criminal history, are we going to ask about kind of the fitness and character?
yeah, I think, look at the, see if this works for you, Micah, but my parsing of the prefatory text, I think it includes entity, controlling person or entity, and entity is used twice. So I think that's covered, but if that's not clear, because if it's, a corporation that's been sued for price fixing or something, whatever, I mean, their corporations obviously can violate the law. We'd want to know about that, it seems to me.
But in the Arizona application, I'm sorry, my page number is a bit off, but under, so I'm looking at a different version. The risk assessment factors is the closest number I can have on the Utah application. Sorry, I was looking at the side-by-side comparison. It does ask, on the Arizona side, it asks quite a number of questions related to the entity itself.
The Arizona side defines authorized person, I think, as an individual or an entity. But yeah, because we're not matching apples to apples on terms of both sides of the chart, it was a little hard for me to.
Yeah.
Okay, it's part 8 of the Arizona application.
Oh,
That's questions about the entity.
Thank you, Kevin.
Okay. Well, I think, let me play this back then. I mean, it seems to me that, keep me honest here, that the principals, the key individuals, we want to get this information for, and we also want to get it for the firm, the company. So if we effectuate that either by adjusting and clarifying the introductory text and or doing a separate list, which is certainly possible, does that make sense to folks? Really, the policy question is, we want to make sure both, if it's an entity and it's gotten into trouble in the past, we want to know about it. If it's a person, they got into trouble in the past, we want to know that too.
Yeah,
I think the call of the question covers it. It says, has the business entity, designated principal, compliance lawyer, or any, in all caps, authorized person? And then it starts with the questions 1 through.
Got it. Okay.
right. But what's in the table is from the Arizona individual application, correct, Kevin? And what we're looking at on the screen right now is from the ABS application. So they're different slightly.
Yeah, I'm referring to part 8 of the ABS application.
The part 8 of the ABS application just has this part. So this would be what would go to the entity and not the individual.
Yeah, I think it might
That's
be
9.
important.
Wait a minute. 5, 6, 7, 8. Wait, oh yeah, that's 8. That's true. Okay.
Yeah, we might want to keep them separate.
Right.
Entity questions and then the constituents of the entity questions. They probably should be separate. At least for now.
Yeah. So any objection to that approach? Keep them separate, but make sure we get information on both the entity and the principals. Going once, going twice.
Yeah, I guess. Well, I don't know. Still.
Well, you're going to see this again. So yeah. Okay. All right. Okay. Well, I think
that section 8 is not in the chart, and what's in the chart is section 7.
Yeah, I agree. I think that's right. I think Marta and Kevin caught a lacuna here, because I think both were important.
Okay, in my notes, I put a note of it, and Kevin, when I send you this kind of laid out, it'll have it in there for you.
Okay.
Great. And then if I can quickly jump in before we go on to the next topic, it's AB 2138 that was the ban the box equivalent, not for employers, but for licensing entities. And it may not apply here because we're not in the consumer, we're not regulated as a consumer entity. but we might want to at least bear it in mind and make sure we're doing something parallel to it in what we do.
That was 2138.
Yes.
Okay, just making sure.
Is it 2838? Did I miss John?
2138.
138. Okay. All right.
Adds language to the Business and Professions Code.
Okay. Great. All right. And then I think the last bit here from my perspective is the follow-up questions with respect to criminal conduct, which would have been covered by the yes check. So that's on the Arizona side at page 12. It seemed like reasonable follow-up questions, but thoughts?
I'm sorry, because the formatting has changed with what was sent to us originally. And so that's not.
Are you talking about this, Tom? This?
Yeah, that part.
Okay.
Right.
So it's just at the, well, it's shifted because I've made notes, but it's at the bottom of that list, what we were just looking at of what would apply to an individual in regards to background checks.
Okay, thank you.
And just to clarify, there are separate applications in Arizona for an authorized person who is an individual and an authorized person that is an entity for whatever.
And does that affect this at all, or?
The only reason it would affect, I think the only reason it would affect us, just generally speaking, is if you're going to suspend it, are you going to suspend, stock ownership in the entities? If that's going to be permitted, then yes, we should, at least clarify that both entity authorized persons and individuals need to complete that form.
Got it. Okay, that makes sense. Okay, with that understanding, is this okay, at least for the next draft?
Looks good.
All right, we're rocking. I'm done. So to you, Becky, are we in fact at the end of our story here?
So based on the work that we have today, we have a draft application that we can then have our straw application for moving forward to something that's closer to the end.
Yeah. So we'll, with Mimi's help, and I'm sure we'll be reaching out to Kevin and others. We'll put together a draft, underscoring draft, and then we'll bring that back to you at our next meeting. And then we can, I suppose, report back. Randy and Justice Tuger, keep me honest, that we're, this is conceptually where we've landed, and, that we're gonna look at this some more. Because I think we're gonna, obviously, there's lots more scrivening.
Tom, do you think it would be useful to bring it to the whole group at the August 10th meeting?
I would defer to the group. My instinct is yes. So we could say broad brush, this is what we're conceptually thinking about, but we still have work to do from our perspective. I think if it was nuanced and a little bit humble, that might be a good thing to do. But I don't want to have anybody feel like we've pushed them too far, too fast,
So maybe as a sort of preliminary FYI discussion, but not for approval.
Yeah, I think that's right. Yeah. I mean, I think today is a very important step in getting to where we need to be, but people need to feel comfortable with whatever final product we come up with.
Rather than perhaps not a full-fledged discussion at our regular meeting, but just provide people for your information. If you have any comments for the scope subcommittee, please provide them in writing, or attend our scope meeting in September.
Yeah, great idea. With the appropriate Bagley Keen, you can't send it to us directly, or send it to Mimi or whomever. But okay. Well, I think I'll defer to Becky, but I'm thinking we've done a great piece of work. Thank you very much, everybody. Becky?
Absolutely. We did, however, make all these really nice people give us even more time, which they have blocked out. And so a question would be, is there something that we might want to move on to? Do we want to move on to talking about David and Kevin's memo, for example, about confidentiality and privacy?
You also have the piece on disbarred lawyers.
And also, do we want to, is on the issues about disbarred lawyers, is that a place where we've had enough discussion and reflection that we could maybe propose a decision?
And I'm happy to continue working on this. I'm also happy to turn back to the massive pile of work that I have at my desk. But since we're all here, maybe we should plow through and see if we can get a little bit more done. I do have a kind of, maybe it's related, maybe not, but kind of a question that's been nagging at me. And I don't know if it's part of the application or part of once someone is accepted into the sandbox, they, sign something, some participation agreement, but are we not going to make sure that all of the participants agree to follow California and federal law throughout the process, the sandbox process? And we can put a pin in that. It's just something that we haven't talked about, kind of.
Yeah, I think that's a great point. We also, and I didn't add it to this, but there's also, an agent for service of process, those kinds of basic things. Let's put a pin in it if you don't mind, Micah, and we'll include it in the draft for you guys to look at. I mean, I think there's some just boilerplate stuff that needs to go in here just to make it complete. But obviously keep us honest when you see the draft. So I'm thinking got 7 minutes to go. I think it's recess time myself, but
I don't want to interfere with recess, but I do like the idea of coming back from recess, if we're going to have one, to address some of the issues that you might be able to bring to the August meeting, and whether that's the memo on disbarred lawyers and so on as a policy recommendation, or some preliminary thoughts on the possibly more difficult subject of the confidentiality and attorney-client privilege issue. I think the more we can pick off new additional pieces of what you've been working on, the better.
Yeah, no, actually that's a point well taken. We did ask for an extra hour, so we've burnt 2, so maybe we should spend some time. I think maybe the disbarred lawyer thing might be a place to start. Becky, do you want to tee that issue up initially, and then we can discuss it?
Well, Tom, to your point about recess, since we have been galloping along for almost 2 hours, do we want to take like a 5-minute break and then come back for disbarred lawyers?
Sounds good. How about if we come back at 3 p.m.?
Perfect. Thank you.
All right.
Everybody.
Thanks, guys. So let's talk briefly about potential agenda. I think disbarred folk and their various potential relationships to a sandbox entity certainly seems like a good one. Is there, are there any other issues that we think we can cover? Becky, to you initially, and then anybody else?
I don't want to speak for Toby and Andrew, but I think they've done a lot of work in helping us think about this. And I think it would be awesome, as the young people say, if we could come out of today's meeting with a recommendation to show to the broader group. That would be one of the first sort of statements about openness and closeness for the box. So,
okay. Well, why don't we turn to the folks that did the most work on this, and if you've got a thought, and I'd appreciate your thought in terms of disbarred attorney providing services or supervising people versus being some sort of minority owner of a business. But in any case, to you guys, how best to proceed? Yep.
Toby, you're on mute.
That helps.
Okay, now you're rocking. Go ahead.
I think we're talking about several different categories, and we need to make sure that we're defining them. There's disbarred, there's involuntarily inactive, there's suspended, there's resigned with charges pending. Those are all the negative ones. And it occurred to me, I didn't include it in the memo. We will talk about it, and that is voluntarily inactive lawyers. Should they be allowed to participate? That's the person who is an active lawyer and decides, no, I'm going to go into the real estate business. I'll keep my law license, but I'm not going to pay the full dues every year. I'm not going to practice law. And how that should fit in. So I haven't given a lot of thought to that, but that just occurred to me. I think our thought was that the four categories, at least the three categories, the disbarred, involuntarily inactive, and resigned with charges pending, should be excluded, certainly from anything that involves the practice of law, including either practicing law or supervising others who are practicing law. Personally, I would take it the next step and exclude them from the process entirely. California doesn't disbar a whole lot of people or put a lot of people into those categories, and there's usually a pretty serious reason for it. And I think it might make sense to say that those are people, particularly while it's in the sandbox form, where we have some control over it, that we might want to say, these are not people that we want actively involved in any way, even as investors, in delivering legal services, whether by lawyers or otherwise, through the sandbox.
Principal position, that sounds good. Anybody, so I can imagine breaking this into parts. One part would be disbarred, involuntarily inactive, and reside with charges pending, no supervision, no provision of services. That's one box. The other one would be universal disbarment, in which would say no ownership interest, no supervision, no direct provision of services. Those two boxes. Are there other things we want to think about or worry about, or does that frame the space we want to reach some conclusions about?
The other issue is suspended lawyers who aren't allowed to practice law, and I think should be excluded from at least practicing or supervising or overseeing, because most suspensions are subject to sometimes relatively short or sometimes long reinstatement period before reinstatement. It might not make sense, particularly someone who reaches that stage while they're already involved, to say, oops, you have to sell your stake and get totally out and go away. And then 3 months later, they're authorized to practice again. And, what do you do with that? Yeah. So I think you might want to divide that one out a bit.
Okay. And then I read this memo, which was terrific, a week or so ago, but who is supervised? Under what circumstances is a lawyer who got tagged able to practice under supervision? And is that something we need to think about here?
No, they are not authorized to practice at all.
Okay.
What they're allowed to do is research, scheduling, non-client connected information. They can't have anything to do with clients. They can't, participate in any way with things that are client facing, or court facing, and they have to be supervised. The supervising lawyer has to report when they hire them and report when they fire them or let them go. there's a very detailed list of activities. And it's very rigid, and I know a lot of states don't go that far, but California does.
Okay, so that universe of people would be covered in the disbarred, involuntarily active, and the resigned with charges.
Yeah.
And then,
Yeah,
okay.
Involuntary inactive.
Okay, and then one clarification, Toby.
Yeah.
How about if you got disbarred in Utah or something? What I presume you would include that, but I don't know. What do you think? That assumes you had 2 bar memberships, I suppose.
Yeah, no, a lot of people do, or even if you were never barred in California, but you were disbarred in Utah. I mean, I think, you still shouldn't be able to participate, would be my feeling.
Okay, so you'd exclude from providing services, supervising services, and ownership across the board. Okay.
Yeah, I would.
And I think other state bars or regulatory agencies do like sister state orders.
Right.
I've seen that where a lawyer,
Oh,
if
that's
they're
right.
barred
Yeah.
here, but they practice in another state, that state bar or whatever the regulatory entity will also, adopt the charges.
Yeah, they call it reciprocal discipline.
Right.
And a lot of times, if a person is barred in California and somewhere else, if they are disciplined in the other state, California will implement that same, or will charge them on that count. And if it's also a violation in California, they will take disciplinary action. But as I say, I would go further and say if they're in one of those statuses somewhere else, they shouldn't be allowed to practice here, whether they're admitted in California or not.
Okay.
And a question for the state bar staff. Is it true that a disbarred lawyer can always apply again to become a California lawyer? I'm looking for nods or shaking the head. And if so, does that ever happen? And what do they have to do to get back in?
I think Mia's on the line. Maybe you could talk to the concept of permanent disbarment and the 5 years for seeking reinstatement.
Yeah, attorneys can seek reinstatement to the practice of law, usually after 5 years. The process is a petition for reinstatement. There is the process in terms of taking the bar exam, which is part of that. And they have the burden to show basically rehabilitation from the underlying discipline for which they were disbarred originally.
And who makes the decision? The Supreme Court?
Oh, state bar, there's a trial and they petition that to state bar court. There's generally a trial and the Office of Chief Trial Counsel represents the basically the office with respect to that reinstatement proceeding. And ultimately the Supreme Court has to approve that recommendation from the hearing department, review department.
Okay, thanks.
The reality is that 5 years is never enough, and it's often much longer than that if people are trying to get reinstated, if they ever do.
So do folks have perspectives? I mean, that just to open the floor to discussion on either a universal ban, ownership, interests, and or provision of services or supervision of the provision of services, or just on the side of providing services or supervising services. Thoughts?
I have a question that comes from both my sort of very casual relationship to these rules, but also my sense that the way law gets practiced would change a lot in Sandbox entities.
Mm-hmm.
And so I think the way we're talking about this now is if I'm a disbarred or a disciplined lawyer, I can't deliver services to people and I can't manage people who are delivering services to people, but can I participate in developing the software that delivers services to people? Can I be an employee of an entity that provides legal services and I do something there that's related to the provision, but I'm not involved in the provision? Does that matter? Am I making up a problem?
Can I help frame frame the discussion, and this might get to what you're asking, Becky. So when we started way back in March, the question was, Toby and Andrew, take a look at how disbarred lawyers should be treated in the sandbox. And I think it's important for the group to understand it's not just disbarred lawyers who are disciplining lawyers, there are these other not just disbarred lawyers who are disciplining California. There are other categories which Toby has identified. And so threshold question, should any disciplined attorney, as described by Toby, be able to participate at all in the sandbox? And this will get to your question, Becky. I think Toby and I are suggesting the answer is no in any manner. However, California's rules of professional conduct do permit disciplined lawyers to do certain things. And so threshold question, if the group says no for any participation, the second question would be, do we want to apply Rule of Professional Conduct 5.3.1 to the performance of services within the sandbox? And if that's true, then the applicant would have to have a lawyer who's going to agree to supervise the disciplined lawyer to do the limited services that Rule 5.3.1 provides. That helps you, Becky. I think that is the way to work through. That's how my mind would work through these questions.
Okay, so the suggestion is that if the disbarred lawyer, disbarred, suspended, et cetera, lawyer is involved in the development of the software, would that person have to be supervised by a lawyer who is involved in the development as well, even though it's not the direct delivery of legal services?
Yes, because it's the indirect delivery of legal services.
Okay, I think it would be a lot easier just to cut them off, disbarred lawyers, because you can slice and dice, but it's just going to become a supervisory nightmare to try and deal with this. I think there's also going to be a perception issue that we're already having, if the ADLs, the public comment on ADLs is any indication, it was very negatively received, the proposals. And to suddenly say, well, yeah, but this is an avenue, disbarred lawyers are going to be able to come into the sandbox in some respect, I don't think it's necessarily going to be a good idea. The other issue, the other box I think that Tom was talking about, maybe not, is the ownership issue. And less than 10% suggests that person wouldn't have any supervisory weight over people who were delivering legal services. So that might be a possibility, but I'm not sure that we should spend a lot of time trying to craft a way for the participation of disbarred. I guess Rule 5.3 refers to them as ineligible lawyers, an ineligible lawyer to otherwise participate in the sandbox. That's my take on it.
Fully agree.
Yeah, stepping outside of my role, I think it's just a political lightning rod if we decide disbarred people can do anything. I mean, I'm with Toby on this one, but one could have principled different answers, and I want to make sure we talk this through.
I think the question that comes up for me with suspended lawyers, keeping in mind that some suspensions are non-disciplinary, they're administrative suspensions. You might want to have a different rule for that. People who didn't meet their MCLE requirement or didn't report meeting their MCLE requirement or didn't
right.
use, it's not a disciplinary issue. As long as they're not practicing law or supervising the provision of practice of law, I don't have any problem with administratively suspended lawyers being owners or writing software or doing any of the other things that would go on, because there's not a discipline function there.
Yeah, no, it makes sense. Further discussion, because it may make sense. I do want to push you, but not too hard. Let's let's talk about this a bit, but I could ask somebody to make a motion. I'd probably ask Toby to make the motion he's just more or less described, and then we could vote on it. But further discussion, I mean, is there, it sounds like we may
maybe
have
one other
consensus.
nuance.
Yeah, go Randy.
Since Toby brought up the different types of suspension, and since Mia was able to tell us about sort of the very specifics of the discipline system, I think there's a difference between just referring to suspended lawyers, even when they're in a disciplinary matter, if the suspension is actual or the suspension is stayed. And so if there's
Suspension is what? Actual versus?
Stayed while they're on probation.
stayed.
Okay.
So I know that's a fine distinction and a nuance, but I believe that if you were just referring to attorneys who are quote unquote suspended, if you've been ordered suspended, you've been ordered suspended, but the order might also say that it's a stayed suspension. So you might actually be able to continue to practice law, which means you're not quote unquote ineligible. And I don't know if I've said anything wrong, Mia, please correct me.
No, that's right. So if it's actual suspension, you can't actually practice law. State suspension, you can continue practicing.
But generally on probation.
So if there's this stay, do you have to be supervised, or you just kind of become a regular lawyer again?
Subject to the terms of the probation.
Yeah, you're still on probation and you're being monitored.
Okay.
Yeah.
I mean, going back to Kevin's point, I don't think we need to overthink it. You know, if you are rendered ineligible to practice law, you should be outside, you know, not able to enter into the sandbox. There are these nuances, but if any of the nuances permit you to provide legal services in some way, again, I'm only staff, but my personal view is you can provide legal services outside the sandbox. It would seem reasonable that you could also provide those services inside the sandbox.
Yeah.
But again, that's up for the group to decide.
I'm comfortable with that.
Well, why don't we, unless there's further discussion, I'm going to ask Toby to make the appropriate motion. Anything more? Okay, Toby, make a motion.
Let me try to put this into some kind of reasonable form. So
you could accept friendly amendments from Andrew too, but go ahead.
That anyone who is an ineligible person under the definitions of Rule 5.3.1 is not eligible to participate in the sandbox in any form.
Okay. Any friendly amendments? Second?
So this, 1 second. Sorry, not to overcomplicate, but there was a prior discussion about someone who's been subject to discipline in another jurisdiction. Do we want to envelop those folks in this motion as well?
Why don't we just do a friendly amendment to include in any jurisdiction?
Yes.
Yeah, I think that makes sense. Okay, second?
The Rule 5.3.1 or any jurisdiction.
Yeah.
Something like that. Okay.
And that would,
you're still okay with that?
okay, that would include not just disbarred lawyers, but if a lawyer is suspended in another jurisdiction, anyone who satisfies the ineligible definition.
Right.
Okay. All right.
So quick question for clarification. So what if when they apply to the sandbox, they are not suspended, they're not disciplined in any way. Once their application has been accepted and the proposal is in effect, then the lawyer has a period of suspension. In terms of if this person is an owner of this business entity, what are we saying about that entity being able to continue to practice? Does the entity no longer have the ability to practice at all? Does that person need to leave the entity? Just trying to understand if they're not suspended or disbarred at the time of application.
Yeah, and that same issue becomes an issue of somebody who's got a suspension, which might be for 6 months or something else that's not a permanent kind of or long-term kind of situation.
What happens now for lawyers who are disciplined and work for law firms? Surely the law firm doesn't have to shut down and stop practicing law.
No, but it depends on what the person's role would be. They would, if they're the lawyer in this thing that's overseeing the practice of law, it might have to shut down. If it's a solo practitioner, they have to shut down. And
Yeah, but if it was, 100 lawyer law firm, one of them got suspended, the firm would presumably continue.
Yeah.
But that person would have to leave. And I think to answer Donna's question, similarly, that person would not be able to participate in the Sandbox entity. Trickier question if they are the sole owner. Toby and I talked about this briefly. I mean, I don't know that we can dictate it, but there might be some options. They can sell their shares or have someone else hold them if you're suspended for a period of time till your suspension becomes reinstated. This might just be over-regulation, not over-regulation, might be overthinking all the variants that could take place. But I think the policy in terms of how this motion is written is that whether it's the application process or whatever continued oversight is going to apply to the entity in the Sandbox. Yeah, they would owe an obligation to tell the regulator if the eligibility status of any of their lawyers has changed, because the policy would require that.
Yeah, we incorporate in the regulatory framework a self-reporting obligation.
Right.
Yeah,
I hope that answers your question, Donna.
And also an obligation to update the application while it's pending.
Yeah.
Right.
Okay.
I guess the other minor piece is that if somebody is voluntarily inactive, that they can take any role in it except practicing law or supervising the practice of law.
They're not ineligible, they're just inactive.
Right.
So that's the distinction.
Yeah, somebody who's gives up temporary, who goes on inactive status because they're now CEO of a corporation, or they're actively practicing in Utah and they don't need their California license right now, or whatever. There's lots of reasons people go inactive. My daughter is inactive.
Yeah,
of course. Defined under the rule, ineligible means disbarred, suspended, resigned, or involuntarily inactive.
Yeah. Yeah.
Right.
Yeah. Yeah, because inactive, I mean, you can't practice law. I mean,
right.
So yeah,
you're
But it's
voluntarily
not right. But it's not because you've been disciplined.
Right.
You're voluntarily inactive.
Right.
I agree with Toby. I think there's an important.
I think I'm certainly open to perspectives on it. I mean, I think I'm comfortable with us going back to the broader group with the policy decision that's reflected in Toby's motion, and that's been seconded, and then we can, if there's additional complexities, we can roll with it and think about it some more. Is kind of my sense. But I'm always trying to get to yes. So that's maybe just be me. But thoughts on that?
I think this is a nice bright line rule that is easy to digest. And I think it's very fair. And I think we can, for whatever it's worth, take this back to the full group.
Okay, then let me call the question and ask Mimi to do the vote thing.
Are we going with this language for the motion then?
Yeah.
Okay, so that was a motion made by Toby. We have a second?
Kevin?
Yeah, I second it.
Okay.
And
right.
there is a friendly amendment
Except-
after rule. Yeah, go ahead, Mark.
Yeah, there was an amendment that it would be, it's not, see the rule
5.2.1.
Yeah, how I had it drafted was after
5.1 is only in
5.3.1.
California, but it would be ineligible in,
Any jurisdiction.
right, in any state or any jurisdiction, right?
Yeah, I said comma, or any jurisdiction, comma, is not eligible. I don't know if that's captures it, but that's just in my quick notes how I wrote it.
Yeah.
All right.
Right.
Ineligible or is not eligible?
Ineligible.
Ineligible.
Okay.
Yeah, that's the way the rule uses it.
And did we want to add the voluntarily inactive piece?
No, because voluntarily inactive isn't part of ineligible definition.
Right.
Okay,
Yeah.
keep that separate.
There's no valence on voluntarily inactive.
Right.
Okay, any further discussion?
Well, just on the point of the voluntary inactives, I think we still should address them separately at some point, because the issue there, while it's not any sort of inherent finding that they're disabled from practicing law, but there is the policy that if you're inactive, you're paying the inactive rate. If you're going to be participating in a practice of law, business or activity, then a matter of fairness, you should be paying the full freight. You should be paying the active dues, you should be doing MCLE. And so for voluntary inactives, I think we do want to circle back to them.
Yeah, I mean, it strikes me that it's automatic that, I mean, that's just a separate body of law, if you will. I mean, if you're inactive, you can't practice law in California, full stop, right? Or
Right.
yeah, okay.
But you can do anything else related to the sandbox other than practicing law. You can write software, you can manage the business side of things, you can
do all that stuff. Yeah.
Invest, any of those kind of things.
All right. Okay. Anything further? Because we'll go ahead and call the question. Okay, Mimi, you're up.
All right. Tom Green,
Yes.
Becky Sandifer,
Yes.
did she say yes?
Yes.
Okay. Marta Alkenbrock,
Yes.
David Engstrom,
Yes.
Micah Star Liberty,
Yes.
Kevin Moore,
Yes.
Toby Rothschild,
Yes.
and Patricia Gutierrez.
Yes.
Thank you.
You guys rock. Thank you. This is terrific.
Okay.
All right, let's think about something else to do.
There was one other issue we addressed in our memo. I don't know if you want to take it up, and that is
go ahead.
As the issue of somebody with a felony conviction. And our thought on that was that it wouldn't automatically prohibit the applicant's participation. It would depend on the nature and timing of the conviction, and all of that would be part of the background check, character and fitness review.
And we might have to incorporate AB 2138 that Justice Tucker pointed out earlier.
Right.
If you have a 7-year window.
I think that only applies to the Department of Consumer Affairs.
Okay.
Taking a quick look at that, but we'll track it down for sure.
I wonder if that, I mean, I'm of two minds here. I'd like to get to yes on something else, but if there's some legal stuff we need to think about, maybe we should roll this over to the next occasion that we get together, but
that's fine.
Okay.
Just to frame it, I think our thinking was, felony convictions should not be per se disqualifying. I similarly don't think it's per se disqualifying to apply to be a lawyer, but it might be a factor to be considered. If it's a crime of moral turpitude, if you're stealing, if you're somehow dishonest, those are things the State Bar and the Supreme Court looks to with respect to applicants. I would imagine, I think it's, again, seems reasonable that you would want to inquire about those things with a sandbox.
It was yesterday, as opposed to 20 years ago, a whole range of things.
Right.
Oh, well, that's a complete, I mean, I just to play this back to you, Andrew, I mean, it strikes me that that's a different question. I mean, we just voted on a total ban,
right?
Which is very substantive, and asking questions. I think we've already set ourselves up to ask just precisely those kind of questions. But am I missing something? Yeah, okay.
No, I think that's right.
I think that's what our recommendation was. Toby, correct me if I'm wrong. I think that's kind of where we were, we were here to present to you guys for consideration.
Yeah.
And that is how it's handled in the moral character process for applicants to the bar. There is no conviction that is in and of itself disqualifying. You get to look at rehabilitation, how long ago it's been, what you've done since then, recognition of the conduct. So it would seem like that same kind of rule would apply. Since you're looking at a character and fitness kind of determination here anyway, you could use the same considerations.
Exactly.
Well, does that create an opportunity to, I mean, if here would be the quick trial balloon thought, if we were to just incorporate the approach the bar takes to, felony convictions, is that something we could approve today? Or do we want to think about it a bit more? I don't want to press people because we've not really run through this in any detail, but thoughts?
So the substance of the position we would be proposing is we want to know about it, but there's no inevitable relationship between the knowledge we have and the decision that we make.
Right.
Okay.
I mean, that seems fair to me. I mean, I'm a prosecutor on some days, so it seems to me if people have paid their dues, they've paid their dues, but yeah, I don't know, it's one guy's view. Is that
into the analysis of their moral character, right? They have to disclose it. They have to provide the facts. It's one factor. It doesn't just DQ you, and the fact that you don't have a felony doesn't automatically let you in, right?
Yeah. Right. Okay, that makes completely good sense to me. Do we need a motion on that, or is that sufficiently clear? We just can move on to a different issue. Going once, going twice.
It seems like a natural sort of introduction to the larger question that Micah and her memo raise about what kind of moral, moral certification certain Sandbox participants might be subjected to. I don't know whether this group would consider bringing a motion and is ready to have a consensus or not on who in a Sandbox entity needs to be screened and against what standard, whether it's the same standard as the lawyers need to get screened to or not, and whether it applies to a single person overseeing legal affairs or to some larger group of people or to nobody, or I don't know, but that seems like a ripe area for discussion.
That seems like a follow-on. We've got a half an hour. We can at least start. This to you, Micah. Do you want to just briefly sort of surface your vision of what might be a standard and who might meet the standard for being debarred for whatever it is they did?
I'm sorry, a standard for?
Or you failed our standard for moral turpitude. What's the standard and how do you violate it?
Well, I think it's a bunch of factors. So just taking a step back, what I was asked to do was to come up with a policy, not a structure, not an application, not questions that were, geared towards finding out one thing or another. And it was suggested that I take, anywhere between a paragraph and a page. I went a little over a page because I didn't have time to write it shorter, right? So, I mean, there's so much to be said for related to this issue, but what my task was to just create high level policy language if we were going to have a moral character like process or analysis, which I am in favor of. I think we need to have something that is exactly the same as what we would require of our attorneys. They don't need to have the same education. They don't need to have, they don't need to take a baby bar or pass the bar. But in terms of, who they are, who the entities are, if they have existed, we need to have some way to look into that and to analyze it. And so what I suggested was we just go through something very similar to the actual moral character process that the State Bar does. It's already familiar with how to do it, so I'm sure the State Bar would love, contribute employees with that experience to whatever the entity looks like that's created. But we're going to have a big perception problem in terms of the people that we want to, rubber stamp or approve this stuff down the road if we're suggesting that the people who are applying and participating don't have to meet a fairly rigorous standard for moral character if they're going to be providing legal services.
Sure. Is there, oh no, that's interesting. Well, but if somebody's providing legal services, presumably they're a lawyer licensed to practice in the state of California. So is that a problem? I mean, if we want to use the same standard as the bar, isn't that circular? Or I'm sorry, go ahead.
No, I mean, aren't we suggesting that other kinds of entities come in and provide legal services? I thought that was kind of the whole
Part of the Sandbox.
Right.
Oh, point well taken. Absolutely. You're the one who said to the non-lawyer. Okay, got it. Absolutely. You're absolutely right.
Well, right, and I don't know what the paraprofessional program is doing. I don't know what that group is doing, if they're looking at certain application standards as well. But, you know, those paraprofessionals have not gone to law school. They haven't passed any kind of moral turpitude test, but certainly their background should be considered.
Yes, so they are importing the moral character determination process in the
Oh.
recommendations from the paraprofessional working group as well.
Oh, really? Okay.
Great. I should have called them and asked them for their policy.
Yeah, for sure.
I just want to raise an issue as an empirical observer of professional work. I totally understand. Well, I understand two things. I understand that we want to protect consumers from irresponsible, incompetent, and unscrupulous people. Absolutely. And I understand that we want that this is a new thing, and so it has scary aspects, and we want to be responsible and also to appear responsible about those scary aspects. I don't know of any research that shows that the traditional way in a US jurisdiction we would do these moral character assessments is particularly effective. And this is an opportunity to think about a way that might be more effective. I'm not saying I have that, but I mean, this is an opportunity to do it better.
Ridiculous thought that what we're doing isn't the best possible way to do it.
Yeah, I mean, I'd love to, I would love to hear what those ideas are. I don't particularly have any. And there are all kinds of lawyers who have passed the moral character and who do some pretty nasty things. Hopefully we catch them in our system and they get disbarred. I don't know that there's any, I mean, there's certainly no way to absolutely prevent whole-scale harm to consumers. But we have a process now that's what we follow for lawyers. We shouldn't do anything to decrease that or dumb it down. If there are ways that we can add some more aspects that are going to provide more protection, I'm all ears.
Agreed.
Let me just mention that one of the attractive features of importing the attorney process is because it's tried and true and tested in terms of the due process and equal protection aspects, since this is an activity to engage in a business to be licensed. I mean, Mia could speak to it more, but there's an entire process where if an applicant gets an adverse moral character determination, they get fully protected by due process so that they can overcome that if they successfully challenge the adverse determination. And so if we found a better way, a different way, then I still think we'd have to worry about the due process and equal protection aspects of whatever that new process is.
Right, because it's a quasi-governmental entity. I mean, if we were a private group, we would have to meet a much less rigorous standard. But I mean, I think there have been suits, have there not, Randy? Isn't that how we or did we avoid any lawsuits because we have such great due process protections?
I'm not sure if we have Brady here today, but knowing us, the state bar, there probably have been suits, but the challenges to moral character oftentimes arise within the moral character proceedings themselves.
I wonder whether verifying the information submitted in the application might serve as a counterpart sort of equivalent to the moral character evaluation, because we just talked about an application that was going to ask about whether certain people have ever declared bankruptcy or been, had a judgment outstanding against them or various other things. And if we were satisfied that we had the right list of things that would catch the grifters and the cheats, or the people under financial pressure so that their best instincts are somehow held at bay by the need to run a pyramid scheme on the backs of California consumers or whatever, that might substitute for something that's like the moral the moral character evaluation.
Well, I think the moral character evaluation asks a lot of those same kinds of questions. The piece that's missing from the application then is the evaluation of the information once you get it.
Right.
Does this, we now have all this information about their financial situation and their criminal history and all those things. Somebody or some group need to take a look at that and say, okay, is that disqualifying? Are they okay? That's the piece that needs to be done. It can't be based on a checklist.
Yeah.
Isn't that what the application process does? It determines whether one enters the sandbox in the same way that the moral character process determines whether someone is allowed to join the bar. I mean, I don't think this is an evaluation-less process. Just because we have a check the box thing as part of the application.
Right. No, it's the next step. It's the next step for both. So the moral character application, is an application, just like the sandbox application is an application. It's the analysis and, the people who take that information and verify it and analyze it. I think there are interviews. I mean, we could probably, I don't know if Mia has information about the process, but it's that next step that has to happen in both regardless.
Yeah, it strikes me that's correct. I mean, assuming you verify the information and, somebody ran a Ponzi scheme 10 years ago and they were, found guilty of, perjury 2 years ago. What do we, those facts are correct. Now, what do we do with them? I mean, I think that guy's gone, but
yeah,
if it's, burglary, when he was 20, that probably wouldn't resonate with me, but it's, so you need some judgment in there.
Yeah, I know Donna can speak to it too. Within the Office of Admissions, the information submitted is reviewed and verified. And oftentimes what comes up is the failure to disclose the information is sometimes the issue, is when they don't disclose their conviction or the lawsuit or things like that.
So is there, to you, Mia, is there like a succinct, here's the moral turpitude standard, or is it really vague?
It's vague. It is, I think Micah may have linked in part to the information on our website, but there was a significant effort in 2020 to revamp that, or not revamp, but take a new look at the moral character process to ensure greater transparency, consistency in the application of the rules, and really give information to applicants about sort of how the process works and things that, how they may be able to show rehabilitation, sort of factors in mitigation and aggravation. If you'd like, we can have Tara Clark from the Office of Admissions give a 10-minute presentation at the next meeting. And we can send around in the meantime what was originally conceived as a decision matrix, but then for sort of graphical representation reasons was presented in a way that's no longer a matrix. So I think we've changed the title of it. But it will show you, but there's basically nothing that is hard and fast in terms of disqualifying. It really is, here's the scenario. These things would be mitigating, these things would be aggravating, but Tara Clark can walk us through how that process works in admissions, if that would be informative.
The information on the State Bar website is really comprehensive. It's great. It lists the BNP codes. There's citations to the 3 major cases that deal with the process, as well as rehabilitation. That's the in-rank class case, I think. And it talks about, for David, it talks about the further investigation and then informal conferences, what happens after the initial evaluation is done. There's a lot more detail. So there's a ton there.
Yeah, and I will link you to sort of within sort of a couple of layers down within the link in Micah's memo is sort of that revised matrix, which is entitled Moral Character Determination Guidelines. And I think that would be the document that would be most helpful for this group to look at, to get a sense of the things that could prevent somebody from being admitted, and the things that are, yeah, that was something that you did and you shouldn't have done it, but it's not going to interfere with your ability to ultimately be admitted to the bar.
One thing that occurs to me, and that is that my recollection is hearing that the process, character and fitness process, frequently takes a long time. And that may be troublesome when we're trying to get this sandbox off the ground. If everything comes in, we've got all the applications, now we've got to wait 6 months for a bunch of character and fitness assessments to get it moving. Am I right that it's that kind of time period?
You are, but that's largely a volume issue. I mean, some of it is take time to get records, but they're getting 6,000 applications a year. I don't think we're going to start that way at that volume with the sandbox. So it should be, we should be able to process them much more quickly.
Good.
I guess the related question is, who do we want to have subjected to this kind of review? Obviously, it won't, I assume, won't be necessary for any lawyers. So we're only talking about non-lawyers. Are we only talking about non-lawyers who might be in the position of being either the CEO of the enterprise or the director of legal services, or if we go with compliance lawyer or designated principal roles? I think whether it's in the context of deciding how to apply the requirement for moral character evaluation, if any, and in the context of deciding what the application should look like, it would be really helpful to hear the group's thoughts about who needs to pass some sort of individual test.
My sense is I'd like it to see anybody who's doing client related, so it might be a non-lawyer who's actually delivering the legal services to the client, who under the sandbox is authorized to do that. It might be, anybody in a managerial position that oversees the operations of the organization. Maybe it's even anybody with a majority ownership stake or something like that.
Seems to me that there are perfectly good arguments for applying it to all levels or none of the levels of a particular organization. I mean, think about an entity, a Rocket Lawyer or Legal Zoom-like entity, a very large entity with lots of managerial levels. You have, folks at the very top who are charting the basic, business ends of the entity. You have like meso-level people who are managing frontline deliverers of services. Now, Rocket Lawyer, maybe it's largely software-based, but then you have technologists who are actually, coding and tailoring the services that are provided. But maybe Rocket Lawyer also combines that with some individuals who very much at the front line, at the street level, are engaging with clients. And I could imagine up and down that chain, there are good arguments for, if we're going to go this route, for having a moral character type process applied to them. But that just begs the question to my mind, whether we should do it at all. And I think that loops back to Becky's initial point, which is, what do we know about the efficacy of this process? Like, how many people of those 6,000 applicants per year, Donna noted that there's quite a bit of volume, like what proportion of them are actually turned away at the moral character stage? And on what grounds? What's the modal turnaway? And then I've only spoken to managerial structure, but Toby, you mentioned, well, what about the people who are financing it? What about the, in effect, the shareholders or the folks who are putting up the money if it's privately held? Like, should we hold them to it? There's just a lot of questions here. It's not obvious to me that it's just the folks at the top, or just the folks at the bottom, or just the folks in the middle. There are a lot of really hard questions here. And you can imagine if it's all those folks, that it quickly becomes a really onerous regulatory process. It starts to create volume, and then it starts to create delay for a process that's supposed to be an effort to understand whether we can generate some dynamic innovation in a system that hasn't had very much.
I just don't see, I'm sitting here listening and I appreciate what you're saying. I just can't imagine the lobbying meeting that would have to happen with the legislature if there were no moral character evaluation process. I just don't see how politically that would ever happen. And, you know, the Daily Journal headlines kind of write themselves as well. So, you know, I think there are ways to do it. And it should.
I wonder if the who question, I mean, David's point's very well taken, but, you know, if we were to limit this to majority owner, you know, a principal in the Arizona sense or a compliance lawyer in the Arizona sense, you know, we're talking a handful of people that we would run this against. And certainly those people, it seems to me, should be checked. But, you know, and we would be taking some risks. But I think if it was relatively compact in terms of the universe, that might work. And certainly to Micah's point, I think it would be politically way better, frankly, but I don't know.
And I'm sure that the compliance lawyer is a lawyer, so we probably wouldn't have to include that one.
Oh, it's mandatory. At least if you do the Arizona model, that's true. It has to be an Arizona lawyer in Arizona.
At least at this point, we have not said that we are only going to allow into the sandbox entities where lawyers are in charge. Maybe that will end up being a rule we adopt, but if it isn't, then I think the question becomes, are we going to require that the person who serves in lieu of the lawyer in charge passes a moral character test?
Mm-hmm.
So in lieu of the lawyer, this would be the managing partner, basically, the manager,
the CEO or whatever,
CEO or something. Yeah. Okay.
Or in an entity that does multiple things, it would be the director of legal services.
Yeah.
And are we all assuming here that a lawyer who is already a barred lawyer in California would not be re-subjected to some kind of moral character screen?
I think so.
So that director of legal services would presumably be a lawyer, although not necessarily, I suppose. You can imagine, I guess, a business model where you actually have someone who is titled the director of legal services, but is not a lawyer. But I would think in the more likely cases that person is a lawyer, that person is fully barred. You know, maybe that's a clean way to do this if we don't want a really expansive net of people who are then subjected to a moral character like screen. You know, maybe one default rule is the top lawyer in the entity, or the, you know, if there is a lawyer in the entity, the top lawyer in the entity needs to go through the moral character process. And we can assume that lawyer, both because of legal ethical obligations, but maybe because they've also been through the moral character process, will engage in proper supervision of other lawyers and non-lawyers who are you know, populating the entity.
Yeah, of course, a California barred lawyer went through that the first time around. When you become a member of the bar, you get vetted in that way.
Yeah, I was assuming that, but I was saying that given that, like, we would. Oh, I see what you mean. Right. So I see. So I see. I was just making an argument for re-subjecting the top lawyer.
I mean, which may be perfectly good argument. I just.
So okay. No. All right. Well, maybe then it's, you know, in an entity without a lawyer, it's the person who's exercising lawyerly like oversight, or is that non-lawyer director of legal services has to be subjected to it, but not others.
It may be dependent upon what the entity is and what they're doing, as to who is going to have to fall, you know, have this moral character examination go through. I fall with Micah, however, and think that just about everybody, I mean, we are talking about the delivery of legal services. We have to make sure that the people that are doing this and operating this business for the benefit of the underserved or whoever they are serving can pass a moral character exam, period.
You know, there's something Tom just said that triggered something in my mind that I think Utah addressed, and that is, what about out-of-state lawyers? An active lawyer from Florida, can they operate a sandbox entity?
Well, they can't practice law in California. I mean, right? I mean,
well, they can't without the sandbox. But if a non-lawyer
I see what you're saying.
can practice law, and a machine can practice law, can a Florida lawyer practice law in California through the sandbox?
So
It's a way for out-of-state lawyers to enter the California market.
what Utah did is the logically inconsistent but politically palatable thing of saying you cannot use the sandbox to get around the fact that if you want to practice law in Utah, you have to be a Utah licensed lawyer.
Yeah, I think that's the right answer.
Yeah, because I think cases like Beer Brower and those, I mean, you guys are the experts, but okay. Well, we got about 2 minutes left. I think where we've landed is, let me play. I don't think a vote at this point is totally appropriate, but some sort of application of a moral turpitude standard. Donna's going to make sure she's going to have somebody send around the matrix. Thanks to Micah for a very thoughtful memo. And maybe the solution lies in focusing on a handful of, key players inside any of these firms, majority owner and or manager. But why don't we roll this over till next time around, unless you guys, somebody can think of a motion that might work. Toby, I'm looking at you in this regard. Do you have one?
No, I'm comfortable putting it over. I'm wondering if at our next meeting, if we're going to go back into this whole discussion, it would be useful to have somebody from admissions at the bar come talk to us about what the process is and how it works, because we've talked around it. It might be useful to have somebody answer questions.
So you're thinking maybe somebody for the next subcommittee meeting or the next full committee meeting?
No, for the subcommittee. I think we need to work through it before it goes to the full committee.
Yeah, I think in terms of a division of labor, we should probably chew on this a bit and then bring something up that's fairly succinct to the larger group, would be my sense. But
it also might be interesting to hear what Arizona is doing, because it looks like from their application, they're, with their authorized person and their, their legal officers, it looks like they've actually spent some time trying to crack this nut. It might be interesting to hear how they are looking at this as well.
yeah, I mean, that sounds like they would get to the who question we've been sort of wrestling with as well as the standard and stuff. Okay.
Can I say one thing, which is, I think we could probably benefit from having someone from the office come in and talk to us, but I'm not completely sure. It could be that this is the sort of thing we could do on the papers with the expertise that we have. I mean, the basic question I have is, how much more fulsome is the process than something like the application we already have, right? There are a lot of questions on there. We walked through them throughout this meeting. Beyond that, is there a fairly simple interview process, but not much more? Are there lots more requirements than that? I'm involved in the moral character stuff because my students constantly join the bar, and I have to sign a letter and check a box, and it takes me all of about 11 seconds to do so. So if the reality is that our application, as we have constructed it over the course of this meeting, looks an awful lot like the moral character process, then I'm more comfortable. But if it's significantly more onerous, then I sort of wonder, especially if it's going to apply to multiple people within one of these entities. I think at some point it becomes a drag and a tax on the process to have lots of individuals who are swimming around inside these entities that we're imagining being subjected to it.
So the moral character application is somewhat more lengthy, but the process is largely on paper unless there are questions. And the only time there's a sort of, if the inclination is that based on what we see, we would deny somebody's moral character, we would invite them in for what's referred to as an informal conference to have them sort of explain rehabilitative efforts and things such as that, why our interpretation of what's on the paper may not be correct. But it's a fairly lengthy application. Not to say that we couldn't streamline that somewhat. So we can pull that together and do sort of a comparison of what we've all been talking about for the Sandbox application in comparison with what's asked on moral character that doesn't show up on the Sandbox application.
So would it be right to say that the application process is fairly lengthy for some subset of application where there's a red flag that goes up, because that requires those additional steps. But for most applications, it's actually not very lengthy. It's fairly straightforward. If that's the case, then it's consistent with what I'm imagining this application process is going to look like, well beyond the moral character context, which is, as I've noted, an iterative process where, we're trying to design an application that can throw those flags so that we can then initiate that more iterative approach and that more careful approach, that more rigorous approach of really trying to understand what the entity is doing and who the people are that are going to do it.
Yeah, I would certainly say, David, that if you have, nothing comes back from on your driving record, you've got, everything's clean, it's pretty quick. The paper review is pretty quick. No civil suits, no bankruptcies, right? Everything's quick. If there are also sort of reference checks, as you've alluded to, from the law schools and from employers. And so if you get something back from the law school that tells you there was an honor code violation, there's going to be more time looking into that. If there was a criminal conviction, there's going to be more time. But the vast majority, I would imagine, are totally clean, and therefore can be relatively quick if we're not sort of overwhelmed by the volume.
Great. Yeah, that's useful. Okay, I'll stand down because we're after 4 o'clock. Sorry, everybody.
Yeah. I think at this point, it's our part, Becky's and mine, and she'll say some words. Thank you very much. I think this was extraordinarily productive. We've got now an about to be birthed draft application. We've dealt with disbarred attorneys. Now we've got to deal with moral turpitude, but that's for our next meeting. So Becky, to you.
No, thank you all so much. This has been an incredibly productive day. We've moved the ball very far.
Worth the extra hour.
Yeah.
Okay, cool. Thank you all.
Thanks,
Have great
everybody.
weekends.
Thank you, everybody.
Bye.
Bye all.